Good afternoon, and welcome to today's New York City Council virtual hearing for the Committee on Consumer and Worker Protection. At this time, can all participants please turn on their videos and silence all electronic devices to minimize disruption? Chair Epstein, we're ready to begin.
Hi, good afternoon, everyone, and I hope you are taking care of yourself during this snowstorm. I appreciate everyone joining us virtually. I'm the chair of the Committee on Consumer and Worker Protection. So I had to hold this virtual hearing today just because it's an important topic that we wanted to get through, and I really do appreciate everyone's time. Thank you for joining our oversight hearing on the Consumer Protection Law, as well as the introductions 177 and 410. Would like to acknowledge some of my colleagues who are with us today. Councilmember Artebal, we have Councilmember Riley, as well as Councilmember Brewer and Councilmember Banks and Councilmember Hanks, who are with us right now. I'm sure other members will join us as we go on with the day. The city's landmark consumer protection law is enacted in 1969 to protect the public from deceptive and predatory tactics. In 2021, the council updated the consumer protection law, protecting New Yorkers from digital and electronic trade practices, really with the growth of online commerce. At the same time, the federal government has failed this responsibility to protect vulnerable New Yorkers. This requires New York City to step up and do more. Tens of thousands of New Yorkers are being victims of deceptive practices and impacts their ability to remain in New York. During the hearing today, we'll examine the DCWP's enforcement efforts to ensure that every business, whether online, brick or mortar, is complying with the consumer protection law, and that every New Yorker across the boroughs have the tools they need to file complaints with city agencies when they're victims of deceptive and unconscionable business practices. We'll also be hearing from consumer advocates, legal service providers, business associations, and other stakeholders about the emerging consumer protection issues and how might the city council address them. Choices we make now impact the future affordability of New York. We also have two pieces of legislation we're going to move forward. Intro 177, which I've sponsored myself, require DCWP to create and run a program to provide individualized counseling related to federal and state student loan forgiveness, in consultation with the Department of Citywide Administration. Also, Councilmember Riley's bill 410 requires certain retail stores to accept festival benefit cards distributed by health insurance providers. I know we heard this bill last year, but we really look forward to a robust conversation from the stakeholders on these two bills. Now I want to turn it over to Councilmember Riley. I know who wants to make an opening statement about his bill, Intro 410. Councilmember Riley.
Thank you, Chair Epstein, and I just want to congratulate you for chairing your first committee. I'm looking forward to your leadership within the Committee on Consumer and Worker Protection. Good morning or good afternoon, everyone, Chair and members of this committee. I'm proud to speak on my bill, Intro 410, the Flex Benefits for All bill, alongside my colleagues, Councilmember Marte, Lewis, and Narcisse. This legislation is straightforward. If a grocery store or pharmacy accepts credit or debit cards, it should also accept flexible benefits cards for eligible items. For many seniors and people with disabilities, these OTC cards are a lifeline. They help cover fresh groceries, over the counter medication, and other essential health products. Yet, too often, these benefits aren't widely accepted, forcing residents to travel outside their neighborhoods just to use funds they already have been given. And if they don't use it in time, those dollars disappear. Intro 410 removes the barrier, it expands access, supports our small businesses, and keeps critical benefit dollars in our local communities. As the cost of living continues to rise, we have a dual responsibility to make benefits usable where people live. I respectfully urge my colleagues to support this bill, and I'm looking forward to hearing from the administration. I do have to jump off, but Commissioner, thank you so much for being here. I'm looking forward to working with you and looking forward to getting your perspective on this bill as well. Thank you, Chair Epstein.
Thank you, Councilmember Riley. I don't know if any other of my colleagues want to make open remarks before we get started. I don't see any right away. I'm going to thank the commissioner for being with us today. I'll call the representative from the administration to testify. The Commissioner Samuel Lean, who's a commissioner of DCWP, and I'll ask the committee council to administer the affirmation. Oh, Councilmember Ariola, go ahead.
I'm here and I have been here.
Well, I know. I
I didn't
acknowledge
hear.
your-
Oh, I'm sorry if I did
I-
not hear the acknowledgement.
I did.
I'm sorry, Chair.
That's all right. All good.
Thank you.
So from the administration, you're all very small, but I believe it is Samuel Levine, Michael Tiger, and Carlos Ortiz. Is that accurate? Great. Do you affirm to tell the truth, the whole truth, and nothing but the truth before this committee and to respond honestly to council member questions?
I do.
All right, noting for the record that all witnesses responded in the affirmative, you may begin.
Good afternoon, Chair Epstein and members of the Committee on Consumer and Worker Protection. I'll start by asking, can you all hear me all okay? Wonderful. My name is Samuel Levine and I'm the Commissioner of the Department of Consumer and Worker Protection. I'm joined today by our General Counsel, Michael Tiger, and Deputy Commissioner on External Affairs, Carlos Ortiz. Thank you for the opportunity to testify before the committee today on enforcement of the Consumer Protection Law and introduction to 177 and 410. The New York City Department of Consumer and Worker Protection is the nation's leading municipal enforcement agency charged with delivering economic justice. We leverage our authority to bring New Yorkers real economic relief and protect them from predatory, deceptive, and unfair practices that violate their rights as consumers and workers. This includes pioneering cutting-edge protections, such as the city's Consumer Protection Law, Protected Time Off Law, Fair Workweek Law, and delivery worker laws, including the minimum pay rate for delivery workers. Through licensing more than 45,000 businesses across over 45 industries, DCWP ensures fair competition and a level playing field for responsible small businesses that are integral to New York City's vibrant communities. DCWP also provides essential services such as free tax preparation and financial counseling to ensure New Yorkers keep more of what they earn and can plan for their futures. DCWP is committed to making sure New York City is a fairer and more affordable place to live. Over the last 6 weeks, we have turbocharged our efforts to deliver on this commitment. We filed 3 major lawsuits where we're aiming to recover tens of millions of dollars for consumers and workers targeted by junk fees, stolen wages, and exorbitant price hikes. We returned more than $5 million to underpaid delivery workers, and we blew the whistle on a scheme by Uber and DoorDash to drive down workers' tips by more than $550 million. We finalized we finalized a strongest in the nation rule to crack down on hotel junk fees, which will save New Yorkers more than $45 million every year. We stood alongside members of this committee to celebrate the passage of key laws, expanding opportunities for street vendors and protecting gig workers from arbitrary deactivations. And last week, we announced a new data-driven enforcement strategy for protected time off to ensure that no worker in New York City faces illegal restrictions or discipline when they take time off for childcare, health reasons, or other protected needs, including weather emergencies like New Yorkers are facing today. Thank goodness that law took effect yesterday. I am especially proud that we're identifying new and innovative tools to drive down costs for New Yorkers. This month, which we've dubbed Fee-Free February, we are leveraging our existing laws, including our licensing authority, to make New York more affordable and to ensure that honest businesses aren't undercut by companies that cheat. For example, we have sent dozens of notices to tax preparers warning them against illegal fees, while promoting New York's best in the nation free tax prep services alongside Mayor Mondani and Chair Epstein. We have deployed our inspectors throughout New York City to ensure that grocery stores aren't overcharging consumers and that employment agencies aren't ripping off struggling New Yorkers. And just last week, we sent notices to the largest gyms in the city that trap New Yorkers in memberships making clear that trapping New Yorkers in memberships they can't cancel will not be tolerated by this administration. Across the board, we are aiming to send a clear message. The era of ripping off New Yorkers with impunity is over. Whether you're a retiree struggling to afford groceries on a fixed income, a deliverista facing arbitrary deactivation, a recent graduate looking for a job, or a freelance worker waiting to get paid, We are here to fight for your rights and deliver on the promise of a fairer economy. And we could not do that without the broad authority and steadfast support from this committee and this council. Turning to today's legislation, Intro 177 requires the DCWP to create and run a program to provide individualized counseling to individuals about federal and state student loan forgiveness programs in consultation with DCAS. We support this legislation. I have worked on student loan affordability for more than a decade, and I've seen firsthand how student loan debt can drive families into financial distress. DCWP is proud to provide support for student loan borrowers across the city through one-on-one financial counseling at our financial empowerment centers. Our centers provide free professional guidance and help clients address savings, banking, credit, and debt, including dealing with student loan debt. We look forward to working with the council on this and other ways to support student loan borrowers in New York City. Turning to Intro 410, which would require retail stores that primarily sell food for off-site consumption or that include a pharmacy to accept flexible benefits cards distributed by health insurance providers if the store already accepts credit or debit cards. We have previously testified in support of the intent of this legislation. We worked closely with council throughout the legislative process last year, and our understanding was that there was still not full clarity on the potential impacts this bill may have, including potentially large cost implications for small businesses. We look forward to hearing from stakeholders today to gain a better understanding of how the flexible benefit market operates, so that together with council, we can strike a balance between the intent and the real-world implications that this bill may have on small businesses in New York City. Thank you for the opportunity to testify before your committee on our essential work uplifting New Yorkers and on today's legislation. We look forward to working with all of you to further our efforts to protect the people of the city from harm in the marketplace. I welcome any questions you may have for further discussion. Thank you.
Thank you, Commissioner. And if my colleagues, when they have questions, I would encourage them to raise their hand, and we'll just keep stack as we go through for questions for the Commissioner. And we start out with a couple of questions, and then give my colleagues some time to jump in here when they're ready. So, Commissioner Lee, can you tell us, how many complaints on average you get in 2024, 2025? How do people report those complaints, and where do these complaints come from?
Yeah, so we received about 27,000 complaints in 2025. Remind me, Mike, how many we received in 2024?
Also 27,000.
About 27,000 complaints the year before as well. And these complaints come from all different sources. We hear from consumers who call 311. We hear from folks who go to nyc.gov/consumers or nyc.gov/DCWP. We also hear directly from council members whose constituents encounter problems. My philosophy is very much no wrong doors. If New Yorkers feel they're being cheated in the marketplace, we'll find a way to take in their complaints. And I should mention, council member, we accept complaints from all New Yorkers, regardless of their immigration status. We welcome those complaints, and we also accept them across more than a dozen languages.
Right, and you can actually also submit complaints anonymously, and especially in this very difficult times for immigrant New Yorkers, you can have advocates submit the complaints on your behalf, and the advocate can act as the liaison with our agency as we try to sort out the best way to resolve the complaint.
And then, so when you get these complaints, like how are you categorized? How are they recorded?
Yeah, well, one of my priorities is making sure that we are responsive to what's happening on the ground in the city, that we're directing our resources to where we're seeing the most problems. So the categorization is very important. Mike, do you want to get into how we crunch those numbers?
Oh, absolutely. So as the commissioner alluded to, there's a variety of channels that you can submit complaints to the agency, but whatever channel that it is, whether through 311 or our online website or through our external affairs division, through council members' staff, it eventually reaches our consumer services unit, and they're the intake and mediation arm of our consumer protection work. And they will try, if possible, to mediate complaints and get money back into consumers' pockets without there even being lawyers involved as quickly as possible. And the great thing about having a robust consumer services unit, it does allow us to get a lot of data and categorize it. So we, as the commissioner alluded to, license 40 plus license categories. For each of those license categories, we can then take a run. We license used car dealerships famously. And so we can say, okay, what are the used car complaints of this period to this period? Who are the worst actors? What types of complaints have come in? That's just one example of how we can crunch the numbers. So all those inputs that the commissioner is alluding to end up in this edifice of data that we can then mine to see what's going on the ground for New Yorkers.
And then our staff specialize in areas, or does everyone take in all kinds of complaints and do the investigation?
I think our mediators are generalists, and they try to resolve any sort of complaint that comes in. Our attorneys are also, I would say, generalists, but as is natural when you're in a workplace and diving into consumer protection works, you end up having subject matter expertise in the cases that you work. So we have people that have worked on a bunch of used car cases or home improvement contract cases or debt cases. But generally, any of our attorneys can work on a variety of matters at any given time.
Right. And then are you prioritizing certain cases over other cases, things that take higher priority than lower priority?
My general view is we want to prioritize where we're seeing the most harm in the city. So one of the patterns you may have noticed over the last couple of weeks is we're really trying to take on some really big cases. Our case against Radiant Solar, for example, was the largest solar home repair case the department's ever brought. Our case against Extra Space, this is a large publicly traded company. So we're certainly looking at the number of complaints we're getting, and we're trying to then extrapolate how much harm are these companies doing in New York City, and what's the fastest way we can put a stop to that harm. Do you want to add anything in terms of our triage?
No, that's absolutely. We're trying to actually make decisions. I mean, Chair, you just asked very saliently about how we crunch data. That's why it's always like there's a top-down approach, and there's, of course, we're seeing this. We're on the subway. We see things that are happening, but a real bulk of what we do is a bottom-up approach. What is happening to New Yorkers in real time? That really provides us the data to make those triage decisions that the commissioner is alluding to.
Yeah, I do appreciate all the work you're doing in such a short time. I'm wondering how you communicate with complainants about the timeline for like when they initially file complaints. When are they hearing from someone from the agency? When they know what the next steps are looking like? How does that get communicated to the public?
Yeah, we really try to stay in regular touch with folks who file complaints. Typically when they call, I don't think it takes very long to get a hold of a mediator. Can you remind me how long that would take?
I mean, it depends on like whether we've gotten all the information necessary for mediation. So we have intake staff that are going back and forth with the consumer to make sure that there's enough. That's actually within our jurisdiction, because we do get complaints that are better handled by other agencies, and we try to make a determination about that. Or we may not have the receipts or contract necessary, because we want the mediator to be armed with everything that's necessary for them to have a robust and helpful discussion with the business. But we do try within a matter of days, get to the consumer and talk to them. And we, I think, believe within 90 days, 99% of consumers, are contact and resolved with our consumer services unit. And then for larger cases, like the commissioner alluded to, the Radiant Solars, the Extra Spaces world that are longer term, larger attorney-driven investigations, our attorneys do keep in touch with the consumers that provide the complaints that generate the basis for us to be investigating, and make sure they're aware that the case is going on, and that when we do actually plead the case and actually reach a resolution, they will be made.
Great. So within a few days, you're saying they'll get the initial contact from filing the complaint. In theory, within 90 days of that initial contact, you think 99% of those cases have been resolved in some mediation or some form of way. That's kind of how you generally operate?
Correct.
That's really good to know. And do you give that information up front to consumer during that initial conversation?
I think we try, I mean, each case is different. I think we try to be realistic with consumers. If, for example, it's another agency's jurisdiction, we're going to tell the consumer that we have to refer it out. If we need additional information to pursue the mediation of the dispute, we're going to tell the consumer that, and then it's going to be up to the consumer to, come up with that additional information. But I certainly think we try to be upfront with people about how long things are going to take.
Yeah, that's right.
And those determinations are done orally, in writing, both?
typically orally, but yeah.
Yeah, I mean, also in writing. I mean, our mediators communicate with consumers and businesses in writing. There's set correspondence that we send to businesses, especially if they're licensees, because they're obligated to respond. Licensees are obligated under our rules to respond to consumer complaints or face a penalty. So there's definitely a written correspondence, but of course, we do what makes sense in that moment for that situation. So sometimes, of course, you get someone, a mediator gets someone on the phone, they can get the business very quickly on the phone. So sometimes it is an oral communication.
Great. I know I see Councilmember Banks and Brewer have their hand up, and we'll go to another couple members, then I can come back for additional questions so we have time. Councilmember Banks, I don't know if you're first or second. And Natalie, who was first?
Councilmember Banks was first, so
Great.
I've just unmuted you.
Thank you. Yeah, thank you. I was having issues, but I noticed that the muting is being controlled by the chair. Congratulations, Chair, on your first committee hearing. And I just want to queue my questions up pertaining. Yeah, okay. Yeah. So when it comes to when it comes to the enforcement. I want to better understand how enforcement is playing out across the 5 boroughs and how many consumer protection law violations have been issued and which industries account for the highest concentration of these particular violations, and in particular, are these primary isolated incidents, or are we seeing repeated offenders when it comes to these ongoing misconduct?
Yeah, that's a great question, Council Member, and you're asking us to slice the data in a number of different ways. So we're going to do our best, and if we miss anything, we welcome follow-up on it too. So in 2025, DCWP issued a total of 17,000 summonses. Just to give you an idea of the borough-by-borough breakdown, about 4,600 in Manhattan, 7,100 in the Bronx, 13,000 in Brooklyn, almost 14,000 in Queens, and 589 in Staten Island. If you look industry by industry, there are different ways to crunch the numbers, but I'll give you just a few examples. So in 2025, we had about 554 car wash complaints, 358 tobacco retail dealer, 169 garage and parking lot. Another way to slice these numbers is to look at kind of the categories which cut across industries. The biggest complaint year after year is around overcharging, which is why I think our work is so much on the front line of affordability. But we also get about thousands of complaints about misleading advertising, unlicensed operators, non-delivery of goods that have been ordered. So it really does run the gamut. I don't know if either of my colleagues want to add to that on industry by industry.
No, I think that's a good overview. I think, yeah, as the Commissioner said, Council Member, we're open to having follow-up questions and sort of answering anything that.
Yeah, if you can follow up with those other stats, I would appreciate it. Also, I'm interested in the complaint to enforcement pipeline. You know, of the complaints received by the DCWP, what percentage results in inspections? And of those inspections, how many lead to violations or penalties? What is the average time between when a complaint is filed and when enforcement action is taken? And if also, is there any delays? What are the root causes, and how can we improve the responsiveness when a consumer is seeking relief?
Yeah, these are very important questions. So let me just start in terms of the sort of complaint to inspection ratio. So last year we referred about 3,000 complaints to inspection, and those inspections resulted in about 1,200 summonses. Now, if you're all following the math, you might be wondering, why didn't every complaint result in an inspection? And the reality is there are a lot of reasons for this. We might receive dozens of complaints about a single business. which, to my point with Chair Epstein earlier, if we're receiving a lot of complaints about a single business, that's a good sign we need to follow up quickly. It's also possible we get complaints about an industry that we don't regulate or that's outside our jurisdiction. So we review every complaint to see if it's something we can send out an inspector to address. We aim to send out that inspector if we have the necessary information, it's within our jurisdiction. We aim to send out an inspector within 2 to 3 days, because we think it's really important to show the public that when you come to us, we will act on your behalf. So we try to do that as quickly as possible.
I would add as well, council members, to your question earlier about how I guess enforcement scales up.
Right.
I would note that, over the years, we've certainly tried to balance out our enforcement processes, right size our penalties. In many instances, we have $0 penalties for the first violation that we issue. That said, if we do visit a business and we have found that they have repeatedly engaged in violations of the law, those penalties do increase in that sense. So I think that's part of our practice to ensure that there's a progressive discipline, but also one that is education focused too.
Yeah, I'm sorry.
No, and I'm asking for the chair. Could he indulge me for 1 minute after the panel answers the question, finishes?
Yeah. Councilmember Banks, happy to give you another minute now, or do you want to wait till after Councilmember Brewer goes?
I'm gonna, if I could just ask this last question.
Of course, go ahead.
Okay, and this is pertaining to the small mom and pop businesses. First and foremost, we have a host of those in my district, and I believe that enforcement is should be firm, but it should also be fair. How does the agency validate complaints before initiating action, and what safeguards exist to ensure that the small family-owned businesses that just talked about are not unfairly penalized for like minor or good faith errors?
Yeah, so these are exactly the concerns we wrestle with every day, council members. So in the first instance, when we get a consumer complaint, we act initially on the assumption the consumer is telling the truth, but of course we want to verify it too. All the time we find there might be misunderstandings, that are no fault of the business, no fault of the consumer, it was just a misunderstanding. So certainly we don't just take the word of the consumer and then go barging down people's doors. Quite the opposite. We want to make sure that the complaint is actually substantiated. That's why we often follow up with consumer to ask for additional documentation. We want to make sure that we're being responsive to consumers, but that we're also respecting the due process rights for businesses. You also raised a very important point, council member, but what about mom and pop businesses? And one of the things I'm very committed to is making sure that we are treating them fairly. We know that mom and pop businesses in your district and throughout New York City don't have huge teams of lawyers reviewing all the DCWP and New York City regulations. We know that the overwhelming majority of these businesses want to follow the law, want to do right by their workers and consumers. And that's why our primary mission is not to play gotcha. It's not to find violations. It's to make sure that there's an understanding of what is needed to follow the law. One of the things I'm very proud of that this department has long done and that I want to double down on is their VIP inspection program, where we send inspectors out into districts like yours, not to play gotcha with businesses, but to educate people about their obligations, make sure they understand it. We don't issue summons on those visits. We don't issue complaints. We're just there to help make sure people know what they have to do to follow the law. I would add to that, even when we do then follow up with inspections, many of the violations we find, we don't even issue fines. For example, we issue we find a lot of companies, grocery stores, for example, that don't post their refund policies. But when we find instances of groceries not posting refund policies, we don't issue fines. What we do is it's curable. We give them a chance to fix the problem. Of course, when you see businesses, repeatedly ignoring warnings, certainly when you see businesses systematically overcharging consumers, we're going to take a different approach. But when we find mistakes have been made, but consumers have not been harmed, our first priority is to make sure businesses understand their obligation and can come into compliance. We're not trying to play a game of gotcha with them. Do either of you want to add anything?
No, I think
I would just add to the commissioner's point, year over year, we through VIP or other education initiatives, we conduct thousands of one-on-one educational inspections with small businesses. to make sure that we are not playing this game of gotcha. And along those lines, our resources and materials that we make available in multiple languages as well itemizes for each business the exact expectations that our laws and rules have for them. So it's ultimately about creating a culture of compliance with these educational materials, and ultimately to better serve the marketplace, consumers, and workers.
And just one last point. I think one of my colleagues may have mentioned this before, but we've been enthusiastic supporters of the council's small business relief efforts over the last couple of years, and that has increased the number of curable violations, the number of violations that are for $0 initially, where it's only after multiple violations where there is a financial penalty attached to the violation. And that's something we continue to engage with, and we're always open to having additional feedback from members about violations that might be happening in their district that are disproportionately affecting small and pops and need to be considered about whether any right sizing is necessary.
Thank you, Councilmember Banks, and thank you, Commissioner. And Councilmember Banks, if you have additional questions, we're happy to take them later on as well if you need. But let's turn it over to Councilmember Brewer.
Thank you very much. A couple of things. First of all, the current commissioner should know that it is thanks to your department and to Carlos Ortiz that the illegal smoke shops closed. I closed 93 with his assistance. So I'm a Carlos Ortiz fan. I just want to let you're okay, but Carlos, we'll let you know that. Next is just proactive, because one of the issues is a lot of the stores do not post their prices. And I know in the past, all the way back to Bess Meyerson, that's how long I go back, is that something that you have enough staff to do, something that you're going to focus on? Because it is an issue. I think it's increasingly an issue. I don't know that people complain because it just sort of, kind of the norm is not to have the prices. But I just didn't know if that's something that you're focused on.
You're absolutely right. We don't always get a lot of complaints about it, but it is something that we look for proactively. So in the grocery sector, for example, where we require prices to be posted, that is the #2 category of violations we find is failure to post prices. And we're doing, resources always welcome. We can have that conversation. But in terms of the volume of inspections we do, I think it's quite striking. Among grocery, supermarket, and megastore, for example, we conducted more than 1,700 inspections between November and earlier this month, I believe February 12th. So we're sending inspectors to grocery stores all over the city. We are making sure those prices are being posted. That currently is a curable violation, and we want to make sure businesses come into compliance, post those prices.
I don't have a problem with it being cured. Next question is, I'm the author of Paid Sick Days. People forget that. Well, the New York Times remembered it this week. I was very pleased. But my question is, with all of the different changes, amendments, which are good, how do you feel? Do you feel that there's enough information about people knowing about paid sick days? Is there more that we could do, etc.? It is thank God we had it during the pandemic, but it still needs, I think, more people to know about it. I want to know your opinion.
Absolutely, you're right. I'm grateful for your leadership on this. I'm grateful for the council. I'm grateful for New York City's leadership on this. No, we need to do a better job getting the word out. Absolutely. So with the amendments to protected time off that took effect yesterday, for example, we tried to do a big media blitz to get our word to workers and the people of New York City as much as we could. But we also sent notices to 56,000 businesses, making clear their obligation to follow the law. We also introduced something that is quite pioneering. I don't think any city or any jurisdiction's ever done this before. We introduced a new audit tool that businesses can use themselves to see if they might have policy on paper. This gives them a way of seeing whether people are actually taking advantage of protected time off. I have already heard from folks all over the country who want to learn from this and want to adopt this tool themselves. So we welcome partnering with you, partnering with the council to get the word out, both to businesses and workers about their rights and about their obligations and rights under this law, because it's absolutely critical. These are just words on a page unless workers understand their rights and employers understand their obligations.
Okay. A lot of this, I don't know how much this is you and how much is PD, but the whole seniors get scammed all day long. It's like, I can't believe it's like not #1 on your list. It is because of the internet and social media and so on. So my question is, how do you approach this? Does it go back to, Colo Gerard and your old agency, or is it something that is able to be dealt with locally? What are we gonna do about that if there's anything about the scamming, social media? Everybody gets scammed, but the seniors in particular.
Well, I would love to hire Kalo if she's interested in moving to New York City and working in city government. One of our star fraud fighters at the FTC, as you know, council member. But no, you're absolutely right. We know that there are a lot of predators out there, and that seniors in particular are targeted. One of the biggest things driving these fraud is on social media. And by the way, it's not only older people, it's younger people too. And I know we've had conversations about this, and we do a lot. We do one-on-one financial empowerment counseling to educate people about how to protect their finances. We certainly do enforcement to target major frauds. We do referrals to district attorneys when we bring criminal enforcement. At the end of the day, council member, I do believe, and I know I've shared this with you, that the federal government needs to change how it approaches social media. For decades now, we've had a law that essentially immunizes companies like Meta and TikTok and Google from the explosion of fraud on their platform. There was reporting by Reuters a couple weeks ago that 10% of Meta's revenue is coming from scam ads. These companies are in the best position to take on these frauds, yet the federal government is giving them blanket immunity from prosecution. I think that's a huge mistake from a federal policy level, but we are certainly doing everything we can in New York City through criminal referrals, prosecutions, outreach, and education to try to protect the people of this city. Judith, if you want to add to that?
Okay.
Amen to that.
Okay, the other question I have is I think it's finance, but I did a report with IBO some years ago showing that it's about $2.5 billion, and that was a few years ago, uncollected every year, not just your fines and fees, property tax and so on. But once you fine somebody, it goes to oath, I assume, most of the time. And do you track to see if somebody is paying up, or is that just done by the Department of Finance and oath?
Yeah, this is a really important question, council member, and I'll let our general counsel get into what our procedures are there.
Yeah, once we get a judgment, whether it be from an administrative perspective or we get it in court or it's a result of a settlement, then we work with actually the law department, the court counsel, who then also works with law firms that actually go out and try to collect on any past due judgments that we've received. A couple of years ago, we actually improved our ability to more directly deal with administrative judgments. We're allowed now to docket them directly on the county judgment bills. So that was an improvement that has made some difference. But we're always thinking about how best can we actually, when we actually issue violations and there are penalties, how can we collect on those?
Go ahead.
Thanks to Chair Epstein as well from his time in the Assembly. I would also note there's other tools that we've leveraged.
I'll take the shout out for my docketing bill, so thank you.
There you go.
But Councilmember, thinking about your point on the illegal tobacco shops, I think about that as interesting points of leverage that we were able to bring on illegally operating businesses. And to be clear, really, that Mike and our colleague James Hurst and their teams were able to strategically redeploy our resources to address that issue, close down over 200 illegal tobacco shops, and collect millions in penalties as well by using those particular leverage points and tools.
Yes, let me just double down on what Carlos is saying. That was a very meaningful difference that affected people in the real world. Councilmember Brewer, as you were saying before, like places that were illegally selling to minors, we were able to shut down, but it also was a point of leverage that ended up in millions of dollars coming into the city's fisc.
Okay. The other thing is that the mayor, to his credit, has a task force, I guess, to figure out fines and fees and so on that are not necessary for the smaller businesses in general. So are you part of that task force? Because it seems to me you would be most knowledgeable about how to, who's getting fines that make no sense, blah, blah, blah. So how are you relating to that? How are you participating? How's it going? I think this is an important issue.
Yeah, Councilmember, we are absolutely a part of it. We are taking a careful look at every one of the fines. We assess what the amounts are, where some areas we have control, some areas we don't. We want to make sure that small businesses aren't being penalized, aren't being taxed, essentially. not only by fines and fees directly, but also onerous regulations they can't understand. On the other hand, we really want to be clear that for large corporate entities that really have no excuse to not understand what the law is, we're gonna take a really tough line. We're going to insist that when large corporate actors rip off New Yorkers, that they not only pay them back, but that they pay a civil penalty to the city of New York. So it's really about making sure that small businesses aren't being beaten up through taxes and fines and fees, but also making sure there's real accountability when large corporate actors make a conscious decision to break the law.
Okay.
I would just add, I think this was referenced by my colleague Mike Tiger earlier, but we have always taken a very proactive stance on how we can reduce fines and fees, even outside of executive orders. And I can think of most recently toward the end of last session, working with chairman at the time, now Speaker Menon, to reform many of our license categories, removing anachronistic license categories, removing certain requirements to get a license that ultimately save folks hundreds of thousands of dollars in fees.
Okay. And then just finally, the issue of licensed versus unlicensed industries. Do you break down the complaints that way, or that's not something that you do?
It's a good question, council member. It's not exactly how we break it down, but we do have industry by industry. We do have a rough outline of industries that are unlicensed where we get a number of complaints. So for example, car wash is a big category we get hundreds of complaints about. Tobacco retail dealer, another big category, electronic cigarette dealer. And we are always open to conversations with the council about whether licensing might be appropriate given the volume of complaints we're receiving.
Yeah, and just to be clear, there are two ways you can look at it, and I just want for clarity. There is licensed, so say tobacco retail dealers. There are charges for being, that we have under the licensing law. You're a licensed tobacco retail dealer, and we charge it. And then there are tobacco retail dealers that are unlicensed, and then there are non-licensed entities that don't require a license. So those are like the three different buckets that we can look at. And as I said in response to an earlier question, we're always willing to engage with you and your staff to sort of carve up the numbers in any way that you think would be helpful to have a discussion.
Are there industries, as you're doing this, that should be licensed, that are not licensed, or you don't really have that kind of insight?
I think that's something we want to get back to you on, but I could give you an example of where that's been successful. We were receiving, I think, hundreds of complaints every year about self-storage. And then last year, the council made self-storage a licensed category. We now have much better ability to stop abuses in that field. In fact, the problem was so bad that was what prompted us to bring a major lawsuit a couple weeks ago against Extra Space. So we're definitely proactively looking for categories of complaints where we're seeing major problems, and we'd be happy to work with you to talk about where a licensing regime might be appropriate.
One last question.
Gail, can we?
I just want to ask about newsstands quickly. They are no longer selling newspapers. So down the line, I'd love to hear your input as to what they should be doing, because it's not really fair for them to get a summons when there's no newspaper that anybody's going to read. So something to think about.
Yeah, and that's an ongoing conversation we're having as well.
Okay, thank you.
We see it every day.
Thanks. I know Councilman Audubon. Shirley, do you have questions still, or? And then I'll do Councilman Rose after.
Yes, I did have a quick question about when you provide education to small businesses, do you coordinate with other agencies like small business services that provide or even our business improvement districts to provide information to the smaller businesses?
Yeah, absolutely. Oh, absolutely, council member. I'll say briefly, and I'll turn it over to my colleague. We absolutely coordinate with SBS and other agencies. I've already had meetings with business improvement districts where we've started making plans to do business education pitches in their bids. We love having partners. They help us get the word out. And Carlos, you should add to that.
Yeah, I think the most discrete example we have perhaps is our business education days model or outreach model, where we go and canvass corridors of small businesses with SBS, with local bids, to provide information one-on-one to businesses. And we welcome doing those events as well with the local council members. I think it's a great way for us to engage as a team to educate small businesses.
Thank you.
Thank you. And I want to acknowledge also Councilman De La Rosa is with us, and Councilman Mose, welcome, and please go ahead.
we're going to be able to ask a question after all of Councilmember Brewer's amazing questions, but I'm glad I got an opportunity. Good afternoon, Chair and Commissioner, as well as Carlos, as well as the rest of the DCWP team. I wanted to ask a question around rideshare within the city of New York. In the past, there have been rules adopted under the Consumer Protections Law that addressed price gouging and hidden fees. I also know that the Mamdani administration is working to tackle the issue of junk fees as a whole, and many New Yorkers are concerned about price discrepancies and surcharges for ride shares like Uber and Lyft. The same ride from one destination to another can have a different price, and there is no real transparency from such companies on how these costs are calculated. In Chicago, it was found that rideshare apps and delivery service apps were overcharging users, and we may be seeing the same thing in New York City. What is DCWP's plan to tackle surge charges and rideshare pricing, and how can the agency ensure we end the use of surge charging as a whole?
Yeah, I think this is an outstanding question, Council Member. And I think one of the reasons it's so important to get this right is because what we are seeing in the rideshare industry, what we've been seeing for years, which is to say personalized pricing that's always changing in unpredictable ways. Often the three of us could all request a certain rideshare right now to the same spot and get three entirely different prices. And for too long, these companies have made these pricing decisions in a black box without any transparency by the public or by the government. But why this is so important is because while the rideshare industry has pioneered this work, it is spreading. We've already seen great reporting on how Instacart, for example, appears to be engaging in all forms of price discrimination and price experimentation. We know that the airlines have long been engaged in price experimentation, and there's a big concern out there that grocery stores, especially as they start to incorporate electronic shelf labels, could start using biometric surveillance and electronic shelf labels to engage in their own kind of surge pricing and dynamic pricing. We are certainly looking every day at where our existing authorities can tackle the biggest harms. For example, if prices aren't being clearly posted, if consumers are being deceived, if they're being offered discounts that aren't real, that's something we take very seriously. But we'd also be very pleased to work with you and work with the council on more comprehensive legislation to rein in these practices. And I would identify at least two practices that probably merit the council's attention because they are distinct. One is dynamic pricing. When companies are constantly changing prices throughout the day, that's often what leads to the kind of price gouging I think you and most of us have experienced out in the real world. We know that Speaker Menon has spoken about this issue as well. And the other is what the FTC, my former agency, has called surveillance pricing. And that's making pricing decisions based on an individual's personal data, which raises both economic fairness and privacy concerns. I believe that addressing emerging forms of pricing abuses requires addressing both of these, dynamic pricing and surveillance pricing. It's something we're giving a lot of thought to both under our existing authority, and we're giving thought to how the council might tackle this directly. So that should be an ongoing conversation, I hope. We do have some ideas on it, and we look forward to working with you on it.
I appreciate that. And I definitely have some ideas around it too, and would love to get together offline to discuss how we can hold some of these companies accountable.
Yes. Thank you.
Thank you, Council Mose. I assume that was it. That's it. Okay. I don't see any more hands. I'll dig in for a couple more questions for you. When I say a couple, a few, if that's okay, Commissioner.
Of course.
Yeah, I'd like to talk to you about language capacity because obviously New York is a multicultural city, and can you break down the complaints? How many of them are from English as first language speakers versus non-English first language speakers?
I am seeing if I have those figures, Council Member, and while my colleagues help me to see if we do, I can tell you that we do accept complaints in about a dozen languages, and for those languages we can't support, we have additional tools that we deploy to accept those complaints as well. It looks like we don't have those at the ready. I apologize, Mr. Chairman, but we're happy to get you those.
Yeah, it'd be great to know who's complaining. Are we getting older adults complaining, people under 30, non-English speakers? It'd be great to see who's getting access to you and who's not. So the things that we need to be doing to make your services available to a population that might otherwise be complaining but don't know. I think that would be great for us to have that information.
I'm happy to do that, Council Member. If I could just follow up very briefly. When I was in Washington, we did do research into this. And what we found is that folks who don't speak English, folks who don't make as much money, and people of color often are less likely to file complaints. That is a big problem, because what that means is that then agencies aren't doing the necessary enforcement to protect some of our most vulnerable communities. So one of my priorities as commissioner, and Carlos has been an outstanding leader on this, is getting out. We're not just sitting here in our office. Today, we're just going to be sitting here in our office. But most days, we're not just sitting here in our office waiting for complaints to come in. We're doing about 2 events a day is our goal this year, all over New York City, every borough, to try to hear from people directly about what they're seeing on the ground, including immigrant communities that might not feel comfortable filing complaints themselves, but can work with partners to bring issues to our attention. So we're happy to get you whatever numbers we can, but I see it as fundamental to our work to not just wait for complaints to come in, but to go out in communities and hear from people directly.
Yeah, and it'd be great to know how we use our resources to do that, like hiring nonprofit partners who have relationships in communities, especially non-English speaking communities, who would have language capacity to help people understand the issues and demystify DCWP for them as well. Let's see how much resources we're spending there, and we need to put additional resources into those communities.
Well, Chair, if I could add as well, I think language capacity, to the Commissioner's point, has always been a major priority for our agency in terms of the communities that we need to reach. Within our outreach team alone, we have team members that's combined. We speak 7 or 8 languages. The agency overall, if you look at all of our staffers, we have close to 40 languages that are spoken. Half of the agency has an ability to speak a language other than English as well. I think it's something that we have long prioritized at this agency, because we know that's how we engage with folks out there. And in terms of our outreach model, again, our goal is to be able to say that we've hit 2 outreach events per day throughout the year. A big part is
not helping.
But a big part of that model for sure is tapping into organizations, neighborhood, community-based organizations, going to their monthly meetings, being accessible as much as possible to make sure that we're reaching every community we can.
That'd be great. And it'd be great to see what kind of outreach efforts and how we as a council can be helpful with those outreach efforts. If there are things that we can be doing, I'm happy to reach out to people on our committee and to help figure out how we can do more events together to get to to hard to reach communities.
Thank you, Councilor. We would love to do that, and we already greatly appreciate the work that you've done to broadcast our free tax prep program now, particularly as we're looking to cut down fees for New Yorkers and make sure they have trusted, available resources to them.
Yeah, no, sure. And so can I I know Councilman Brewer raised the issue of complaints that are licensed versus unlicensed industries. Do you have a breakdown of how much of the 27,000 complaints are coming from unlicensed people who are unlicensed or unlicensed vendors or unlicensed industries?
Just to clarify, because I think we're going to have to follow up. Do you mean complaints about industries that should be licensed but are in fact unlicensed, or complaints from industries that are just outside our licensing categories?
I mean, Commissioner, I would say both would be helpful, honestly, because if we see, I think we all read that article in the city, I think around the tow trucks, right? The unlicensed tow trucks, right? So it's a licensed industry with a lot of unlicensed people versus an industry that might be an unlicensed industry where we're seeing a lot of consumer complaints. I think both are really going to be helpful for us.
Yeah, because I think what the numbers I was referring to earlier were industries that should be licensed, but we're seeing a lot of unlicensed. I think we need to follow up on both of those, but we're happy to do that.
Great, thank you. I appreciate that. And so, can we talk about restitution? You mentioned that your goal is to get people restitution. Do you have numbers for 24 and 25 of how many of the 27,000 cases resulted in some level of restitution for the complainant?
Well, I know in the past 4 years, we've secured more than $28 million in restitution, disbursements, and debt relief. I don't know. Let me see if we have the numbers for the last 2 years.
Yeah, or even what percentage of the complaints got restitution. Not that, I mean, great if everyone got restitution, or I'm sure it's kind of weighed in. Some of the bigger cases got larger restitution, and maybe some people got no restitution.
I don't know if we track it by the number of complaints. I can tell you in 2024, we secured 4.2 million in restitution. 2023, 1 million in restitution. One thing to keep in mind, though, is that we do a lot of mediation of complaints where we don't always track that number in restitution. We as we would in enforcement.
Well, I know our consumer services mediators, I think last year got between $300,000 and $400,000 in restitution. And that's incorporated into the total that the commissioner mentioned before, 4.2 million overall by the agency, whether it be through mediation or the efforts of our attorneys through investigations.
Yeah, I mean, that's wonderful. It'd be great to know if you can, what percentages of those of the overall total resulted in restitution or some kind of mediation with some restitution for the individual. It's just great for us to kind of have that data as well. If out of the 27,000, 20,000 people got some through mediation or litigation got restitution, it's very different than if 2,000 people did.
We'll get those numbers for you, Chair. And just to again clarify, last year, 2025, 3.1 million in restitution, and 430,000 of that was through mediation.
That's great numbers. That's really a lot of money back to New Yorkers, so I do appreciate that. And in 24 and 25, I've fully filed a lot of requests to oath. Do you have how many of those applications went to oath versus were resolved through mediation?
I believe, how many applications went to oath? I believe, let's see, we had 17,000 summons. Do you know the answer to that, Mike?
How many
number it out?
How many summonses went to oath?
I believe it was 17,000.
That's we have 17,000 summonses overall. All our cases, except for the handful bigger investigations that go to state court, they all are returnable to oath.
So 17,000 out of the overall 27,000 went to oath for some kind of deliberation?
I would say there's 27,000 complaints the agency received last year. Last year, we issued 17,000 summonses, and all of those summonses are returnable to oath, barring a handful that my colleague mentioned that could go to other venues as well.
But just to be clear, there are Venn diagrams here that are operating. They're not one-to-one necessarily. Not every complaint is something that would generate an inspection, that would generate a summons. Depends on what the consumer actually wants. So
I think that's right. The substance of the complaint will lead to a different pathway depending on the needs of the consumer.
And there are summonses we issue that are not from consumer complaints. So just that we can, again, that's why I said we can sort of work with your staff to dice it however way you think would be helpful for you and your team to sort of engage. But I just want to set those parameters that there's not just one pipeline.
Yeah, at least for me, I mean, it's great to know how many of these resolved through mediation. Then if you're handing it off to oath, what, how oath is resolving these, and if there's any bottleneck for the consumer who's trying to get some resolve. It's really good to hear that you're hearing something, getting back to someone within a short period of time and resolving most of it in 90 days. But if let's say it's getting stuck at oath, that's also important for us to hear as well.
And I can say, Chair, that is certainly a priority for me as well. I'm going to be sure that when we're committing resources to enforcement that we can move relatively quickly. I don't want, one thing you've seen this year, for example, is our willingness to file cases in state court, like the action we just filed against Extra Space. All options are on the table when it comes to making sure we're resolving these cases as quickly as possible, getting money back into consumers' pockets. I don't like to see cases drag on for years.
And Chair, just to confirm as well, last year we conducted 2,100 mediations. And additionally, of complaints we received last year, 3,000 were referred for inspection that the Commissioner mentioned earlier. So that's kind of a little bit of the breakdown right now that we have.
That's good information. We've seen a lot in the grocery retail, a lot of complaints under the CPL. Do you have a sense of why there's been such a increase in this category of charges filed under the CPL for grocery retail establishments?
My sense is that people are getting really frustrated with what they're dealing with at the grocery store. I mean, obviously they're frustrated with the high prices, but what our inspectors are finding is a lot of pretty serious violations at times. So for example, we've seen a lot of inspectors come back and tell us that grocery stores are charging tax on non-taxable items, like feminine hygiene products or over-the-counter medicines. We're seeing failure to disclose credit card fees and credit card limitations. We're seeing sale of expired medication. So, we get complaints for all sorts of reasons, but our inspectors on their own are finding that some of the core protections grocery shoppers are entitled to are not being honored.
I would also mention, Chair, that in many cases, as we were referencing earlier with Councilmember Brewer's questions, Over the past few years, we have had to prioritize inspections of places that are selling tobacco products. And oftentimes these might overlap, a bodega, for example, with a grocery store selling tobacco. It brings us to that place in the first place, and we're also looking at other violations that might be popping up in the course of those inspections. So I think it's part and parcel informed by what's happening in the marketplace, the complaints we're receiving, guiding our enforcement efforts to certain places.
Just one other point, sorry, boring data nerd flag here is that over time, depending on sort of changes made to our internal tracking databases and other things, we may be charging the statute, which is the CPL 20-700 of the administrative code, but we've promulgated a ton of rules, including some of our core meat and potatoes consumer protections. And sometimes in some years we charge the statute, sometimes we charge the rules. And so that's, again, I just want to offer sort of our services and work with your staff to sort of dice the numbers the way we think is best, because I think just as a caution, we don't want to sort of over analyze just looking at these data in the first instance, and want to look underneath them to make sure they're actually reflecting what we're, what our intuition is.
Yeah, I would love to do that. I appreciate that offer. I look forward to doing that with our teams. Can I turn our attention to kind of online deceptive practices? Obviously, this has been a growing portion of your work. Can you tell us how you've been addressing this issue? Do you see, increasing complaints, whether it's cryptocurrency, online deceptive practices? Can you tell us what you're seeing now?
Yeah, I mean, so much fraud today is moving online. And so many of the problems we see are driven by digital interface. So I'll just give you one example, Councilmember, of how we're trying to get ahead of that. One of the initiatives the mayor launched in, I believe, second week, I think, was this executive order on subscription traps. And, subscription traps is a name, it means different things to different people, but where I've seen it is companies that market themselves online. And they say, just click here and you'll sign up for a subscription. There'll be a 3-week, free trial, and then there's $1.99 a month, and there's a little asterisk. And then if you actually read the fine print, it says we're going to start charging you $40 a month on month 2, month 3, month 4. One of the things the mayor said is directing DCWP to put an end to that. You saw last week we sent warnings to gyms across the city, but we know that many of the deceptive practices we see are not actually in the gym; they're online. The Federal Trade Commission just sued LA Fitness for using online deception to track people in subscriptions. We see a similar dynamic in our junk fee work. Digital pricing has enabled a vast number of companies to engage in what used to be called drip pricing, where companies advertise one price, say on Booking.com or Priceline, and then you click through, you enter your credit card information, you go through the whole process, and 10 minutes later you realize, oh, there's a $40 resort fee on the back end. So we finalized, and you were there for this announcement along with Councilmember Brewer and the mayor, the strongest in the nation hotel junk fee rule to require upfront advertising of prices. So we really are, and I have a track record of this going back to my work in DC, working to make sure that our consumer protection laws keep pace with technology. At the end of the day, what's deceptive in person is also deceptive online. I think what's really changed is that companies have new techniques, new tricks that they can use online to get people. And that's why we're really trying to modernize our enforcement and make sure that both our rules and our enforcement reflect the reality of what consumers are experiencing in the marketplace.
Just a couple other specific instances that we've been working on over the last couple of years that the commissioner is really sort of taking the leadership mantle to push us to do even more. We had a case that we filed in state Supreme Court that's still pending against Dorm to Dorm, a moving company that was targeting students online for moving services, but not giving them the benefit of their bargain. That's a case that's still pending in state court. We have a case against Way.com. One thing that we're really interested in here is how online actors can supercharge the deception of brick and mortar and smaller online actors and say, oh, maybe I'd be skeptical if I was just seeing this on the street. But with this patina of credibility of this major website, then, oh, I will actually go through. And then consumers are very prone to, and we're very attuned to making sure that websites are not supercharging and thinking creatively how we can get around the federal laws that the commissioner was alluding to about 20 minutes ago with great vigor about the problem that's happening with federal policy about online actors. But we went after way.com because they were actually acting as a booking agent for unlicensed garages. And that's a real problem we've seen, especially in Southeast Queens around JFK. So, and we've also had a lot of enforcement around lithium-ion batteries. That was something that we've worked with the council a great deal over the last couple of years. And that wasn't just about brick and mortar locations, but also online actors. So we always have an eye to not just what's going on the streets, but what's also going on the internet as far as deceiving New Yorkers.
Thank you. Thank you. I also want to acknowledge that Councilmember Krishna is here too. I want to thank him for joining us. Yeah, I'm going to do two more questions and I'll do other council members 2 questions. So we've heard a lot about small businesses, and do you see a lot of small businesses who are victims of abusive and deceptive practice? And what do you think your role is in protecting those small businesses from kind of larger business who are engaging in that deception?
Yeah, absolutely, Chair. The reality is that small businesses are getting scammed, just like ordinary people are getting scammed. After all, small businesses are led by people. We have scammers going door to door, marketing, payment systems to small businesses that are often frauds. Small businesses get trapped in subscriptions, just like the rest of us do. Small businesses have to deal with junk fees, just like the rest of us do. One thing I've heard a lot from small businesses I've spoken with is that a small business might be next to a Target or another big box store, and that small business pays more, say, for Pepsi than the Target right next to them. And how is that small business supposed to compete when these big distributors are discriminating against them, charging more than neighboring stores? So I think it's a huge problem. Unfortunately, our consumer protection law is limited to it follows the CFPB standard at the federal level, which is personal or household use. That sometimes limits the types of cases we can bring. But I absolutely believe there's a need for greater accountability when small businesses are targeted. We'd be delighted to work with you, to work with the council, to make sure that small businesses actually have tools to fight back when they're being scammed, and to fight back against the kind of price discrimination and other abuses that are driving far too many businesses out of the city.
One case, the commissioner alluded to sort of the limitations of our current consumer protection law and that phrase, personal, household, or family goods. I can give you one example of how we have helped small businesses. Recently, a couple of years ago, the council passed a suite of regulations and a licensing scheme for third-party food delivery services. And we filed a case last year at Oath against Hungry Panda. And the people who are being protected there are small restaurants, because they were being charged above what the fee cap that this council passed permits. And that's a case that we have pursued at Oath. So that's a case where we did have a law and we were very vigorous in pursuing that to protect small businesses.
Thank you. Councilmember Adelball.
Okay. Yeah, I had in addition to fines, what other ways can you deal with violations, consumer scams or price gouging? Is there a requirement for someone who violates the consumer's rights to post something in their establishment or on their website, kind of laying out what consumers' rights are?
Yeah, this is an excellent question, and it's something I think about a lot. Let's say we catch a company breaking the law, ripping off consumers. How do we make sure it doesn't happen again? For a lot of these big companies out there, they can pay $10,000. Some companies can pay $1 billion and not think twice about it and go around, break the law again the next day, because it's not a big deal to them. So I think about a number of tools that we have, I think that we are already using to make sure that companies are actually deterred from ripping off New Yorkers. One thing that has been a big theme throughout my enforcement career, and that I'm very much prioritizing here at DCWP, is individual accountability. In my last job, we sued Amazon for ripping people off and trapping people in subscription, but Amazon can write a big check and not care. That's why we named 3 Amazon executives personally to make sure that they got the message that ripping off the American people was off limits and wouldn't be tolerated. I think that sends a strong message to the industry. That's something we're already doing here at DCWP, whether it's our case against Radiant Solar, our case against MotoClick. We are naming individuals when appropriate, not only to make sure that the message gets sent, that individuals can be liable for cheating people, for cheating workers, but also because to the point we were talking about earlier, we want to make sure we can actually get money back for consumers at the end of the day. That means that if a CEO or an executive runs off with millions of dollars of consumers' money, we want to be able to get a judgment against that individual and get that money back into consumers' pockets. You also raised, council member, what kind of other relief can we require? Notices, injunctive relief. Another thing that we are doing more and more at DCWP is filing cases in state court instead of filing them in oath. What that allows us to do is ask the judge to actually issue injunctions, order businesses sometimes permanently to stop breaking the law. Order businesses, sometimes I have seen this, to notify customers about what happened and send them checks for refunds. That's exactly the kind of relief we have found. When businesses actually have to tell their customers, you got ripped off and now we got sued, we're making you whole, that can send a really important message to the public that New York City has their back, and to other businesses that they shouldn't rip off the people of the city. So we would welcome the opportunity to work with your office to think about the kind of remedies, the kind of interventions that actually stop fraud and that deter fraud. And that is one reason we're bringing more cases in state court, naming more individuals. We want the message to get out there that the era of ripping people off is over.
Shirley, anything else? Okay, great. Can I turn my attention to Intro 177? Can you tell us, and I appreciate your support of that introduction, if this bill gets signed into law, how would your agency use this? How could you integrate it into cities' financial empowerment centers? Kind of how could this be an additional tool for consumers around student loans?
Yeah, so we're excited about this law. And as you referenced, there's a lot we're already doing for student loan borrowers. We do our financial empowerment centers where we provide one-on-one counseling to thousands of New Yorkers every year, including on their student loans. We have a pilot program with Summer where we're offering both for New York City employees and New Yorkers the opportunity to enroll in public service loan forgiveness or income-driven repayment. We do enforcement against predatory colleges, like we brought a case against Berkeley College, recovered more than $20 million in debt relief for students. We do outreach and education, including when we thought that there was going to be student loan garnishment at the beginning part of this year. We're going to launch a major outreach effort. But I think to your point, we need to align those efforts and make sure we're serving as many New Yorkers as we can. We know that between 1 and 1.4 New Yorkers are burdened by student loans. We know that far too many of those New Yorkers are likely facing default. So we really need a coordinated, all hands on deck effort, not only within DCWP, but coordinating with outside partners to serve as many New Yorkers as we can who are struggling with student loans. And I think Intro 177 would be the vehicle to do just that, to make sure we're coordinating our efforts and we're being strategic about reaching us. There's a lot more people we need to reach, and I think this is going to help turbocharge our efforts.
Thank you, Commissioner. And I appreciate on 410, really wanting to figure out how we can make this work. I appreciate Councilmember Riley's bill here. Have you seen complaints around this issue, around flexible benefits cards at retail establishments? Have you heard from consumers at all?
I don't think we've received formal complaints, but that might be because people don't know to complain. I will say, Chair, that I recognize this is a very real problem that the council member is looking to address. We know that people have these flex benefits, and at the end of the year, they often lose their flex benefits because they expire and people don't know where to use them. So I completely agree with the notion that to make the city more affordable, let's make sure New Yorkers can take advantage of the benefits they already have, rather than just letting these benefits line the profits of big insurance companies that have made billions of dollars off ripping off the people of New York City. I think the thing we want to make sure of, and we very much like to work with the council on this, is this can be, we want to make sure this doesn't impose a big cost on the small businesses of the city. I have heard so many complaints from small businesses, corner bodegas, about sky-high processing fees, credit card fees they're already needing to pay. I want to make sure that any requirement that flex cards, for example, be accepted doesn't impose undue burden on these small businesses. But I do believe there's a path forward that protects our small businesses while making sure that consumers can actually spend the money they're entitled to spend and not have it go line the pockets of the insurance companies.
Yeah, thank you, Commissioner. I don't see any more questions from any of my colleagues here, so I want to respect everyone's time. If there are no more questions, Commissioner, I look forward to further conversations, and thank you for, taking the time to talk to us. And there's a lot of follow-up here. I look forward to meeting and getting those follow-up questions answered.
Thank you, Chair, and thanks for the opportunity to speak with the committee in spite of the snow. We really appreciate it.
Thank you. And
Chair, we'll also make sure we have our team monitoring the rest of the hearing so we can get the stakeholder feedback as well on these issues.
Wonderful. Thank you. I appreciate that. And now I want to just turn to our first panel. Carolyn Coffey, Winston Berkman-Brewer, and Isaac Goodman. And we can just go in that order. And so, Carolyn, you want to go first from MFJ?
Thank you, Chair Epstein. That was all really interesting, and I hope to see more that comes out of that dialogue there. So thank you for hosting this hearing today, and thank you to all the members of the New York City Council who are participating. I'm Carolyn Coffey, and I'm Director of Litigation for Economic Justice at Mobilization for Justice, and I'm here today maybe to talk a little bit something a little bit different than we've been covering so far, and that is the need to improve consumer protection for New Yorkers, and specifically and importantly, to discuss the need for New York City to adopt a strong, privately enforceable ban on unfair, deceptive, and abusive business acts and practices known as UDAPs. A strong New York City UDAP is a critical tool toward general enforcement of the consumer protection law, enabling the Department of Consumer and Worker Protection to focus on reforming industry-wide practices like the ones that they discussed earlier. MFJ is a civil legal services organization whose mission is to achieve justice for all. MFJ prioritizes the needs of people with limited income who are disenfranchised or have disabilities as they struggle to overcome the effects of social injustice and systemic racism. MFJ's consumer rights, homeownership protection, and workplace justice projects provide advice, counsel, and representation to New Yorkers with limited and low incomes and who are regularly taken advantage of by entities that treat them unfairly. New Yorkers are regularly squeezed by rising costs and inadequate pay due to corporate greed. Desperate New Yorkers harmed by predatory businesses regularly contact MFJ and are referred by elected officials to MFJ for help with problems related to pretty much every aspect of the marketplace, including, for example, junk fees, as we discussed, mortgage lending, student loan servicing, bank fraud, debt collection, credit reporting, automobile sales and financing, door-to-door scams, and employer malfeasance, among others. But New York's existing laws do little to hold bad actors accountable or to support honest businesses. New York State's catch-all consumer protection law is one of the worst in the country. It's riddled with gaps, loopholes, and such paltry penalties that the National Consumer Law Center has called it toothless and ranks us behind 42 states and the District of Columbia. But there is a solution. As a matter of economic and racial justice, we call on our city council to give New Yorkers a robust and privately enforceable ban on unfair and abusive business practices with meaningful penalties and true access to justice.
Time has expired.
Carolyn, you done, or do you need another minute?
I just really thank you for the opportunity to speak and really call for the city to adopt a New York City UDAP.
Thank you very much. Winston?
There we go. Can you hear me? Great. Chair Epstein, members of the Council and Committee, thank you for the chance to testify. My name is Winston Berkman-Breen, and I'm the legal director at Protect Borrowers, formerly known as the Student Borrower Protection Center. I'm going to talk today about what's happening at the federal level in terms of what needs to happen at the city level. The New York City has long been a leader in consumer protection and financial empowerment, but its existing laws and resources are insufficient to address current needs. These needs are exacerbated by the federal government's near complete abdication of its consumer protection responsibilities and by the affordability crisis that is sweeping the nation. In absence of federal oversight, New York residents and small businesses are vulnerable to unlawful and abusive business practices and to corporate power. Federal law prohibits unfair, deceptive, and abusive acts and practices. However, these protections are primarily enforced by federal agencies, namely the Federal Trade Commission and the Consumer Financial Protection Bureau. Without these two agencies, households and small businesses nationwide do not actually benefit from these federal protections. Under the Trump administration, the FTC and CFPB are not enforcing these laws, and New Yorkers are paying the price. For example, the administration is actively trying to close the CFPB, firing nearly all staff and attempting to cut all of its funding. At the same time, the CFPB has dismissed or terminated the majority of its enforcement actions, stopped complying with at least 87 statutory mandates, rescinded over a decade of guidance and interpretive rules, and deprioritized its work related to certain topics such as medical debt and student loans. Along with Consumer Federation of America, Protect Borrowers calculates that the cumulative effect of these actions has caused an estimated $18 billion in costs for working families across the country. Available data make clear that this federal abdication is affecting New Yorkers. Based on data from the CFPB's Consumer Complaint Database, the number of complaints filed by New York City residents increased by 63% in 2025 relative to 2024, totaling 184,830 complaints last year. The Bronx had the greatest increase at 71%. At the same time that the number of complaints to the CFPB increased across the city, the number of complaints from New York City that were resolved and included relief to consumers fell by approximately 10 percentage points. It's therefore clear from the federal government's own announcements and data that it is not working to protect the interests of households and small businesses across the country or here in New York City. The city can fill the oversight and accountability void left by the federal government by taking two steps. First, as my colleague Carolyn Coffey just said, the city must enact a municipal law equivalent to the FTC's and CFPB's protections around unfairness, deception, and abuse, and must make this law privately enforceable. Second, the city must adequately fund the Department of Consumer Worker Protections. As we all just heard, they do phenomenal work. Again, thank you for the chance to testify. I'd be happy to answer any questions.
Go ahead now, unless there's any questions. Good afternoon, Chair Epstein and members of the City Council. I really appreciate the opportunity to testify today. My name is Isaac Goodman, and I'm a paralegal at New York Legal Assistance Group. Alongside our attorneys, I help advise clients on student loan issues like payment plans, possible federal and private loan discharges. I want to speak today about INT 0177 and particularly why I think it's so important that New Yorkers have a reliable source of guidance regarding student loans. You know, there's kind of a crisis right now in the city. According to federal student aid, New Yorkers owe about $100 million, spread around roughly 2.4 million borrowers. And as I'm sure you may have heard, around a quarter of these borrowers are in danger of default or in default. H.R. 1, or the Big Beautiful Bill, will exacerbate these dire conditions. The bill limits payment options for all federal borrowers, but especially anyone with existing loans for a child who have no longer have access to cheaper payment plans. Students looking to take out new federal loans will face stricter limits on lending, increasingly leading them towards predatory private loans. NILAD's clients managing these debts feel lost amidst the federal government's ever-changing programs and regulations. The resources on federal student aid's website are limited and often incorrect. Federal servicers regularly send clients misleading and contradictory notices, and it can take hours waiting on the phone to actually speak with these servicers to clarify. Searching the internet for help often will only turn New Yorkers towards for-profit scams. The proposed student loan counseling program would be invaluable in reducing confusion and avoiding default. Having a safe and personalized source of guidance would stop borrowers from having to choose between paying their debt and paying the rent. NILAG strongly urges the city to pass this law and grant millions of New Yorkers the help they need to achieve financial security. Thanks again for the opportunity. Appreciate it.
Oh, thank you. I appreciate that. Thank you for the panelists who have testified. I want to see if any of my colleagues have questions for any of them. Just a couple. So I want to see no other hands raised right now. Let me go to I want to talk a little about the private right of action and why is the private right of action important in this moment. Now we heard the DCWP's increase in enforcement. Why do we think a private right of action is an important tool today? And anyone can answer. Caroline, I don't know if you want to do that.
Yeah, sure. I think, we heard some of the great work that the DCWP is doing and other regulators in the state, and that they play a really important role in keeping businesses in check, but there are not enough of them. They have limited resources, and there are so many issues that just can't be addressed in a pattern and practice type of situation. And so you really need to have individuals who are empowered to bring cases, to bring actions, to threaten to bring cases against businesses that mistreat them. And so many of our clients are people with limited income, people who are people of color from communities of color who are just mistreated, and their businesses are taking advantage of the fact that no one is going to step in to help them. And so we really need to empower individual New Yorkers to be able to bring to level the playing field.
Would the legal services community itself have the resources to? Because obviously, if you have limited resources as well, you just feel like it's just another tool in your tool belt as an option.
It has to be, and the legal services, MFJ and NILAG, we can bring affirmative litigation, and sometimes that's important to do that kind of impact work. But even being able to send a letter to a business that has mistreated one of our clients and threaten the legal ramifications that that could befall the company, that sometimes they will just resolve an issue because they know that the law is on our side, and so we don't even have to go to court. And so there are ways to utilize a strong consumer protection law that will again empower individuals and just put money back into their pocket, which is what we're really only after here.
Thank you.
Chair Epstein, may I add to that just
Yeah,
very briefly?
please do.
I think one additional gloss I would just add is that our rights as individuals, as New Yorkers, shouldn't rise and fall it shouldn't be enforceable or not enforceable based on the position of the federal government or the resources of the local government, right? So New Yorkers should be able to have their rights upheld and enforced regardless of who's in the White House and regardless of whether we're on an austerity budget or we have a budget surplus that can make sure DCWP is adequately staffed. And I, again, will reiterate that I think we should, and I think the mayor's even called for doubling it, whatever it is, we should give DCWP significantly more resources for staffing and investigators, et cetera. But even in the most robustly staffed agency, and if we had someone in the White House who wanted to enforce these federal laws, private enforcement is complementary. It's very much sort of a three-legged stool of state public enforcement, public regulation, and private enforcement. And these fact patterns and cases often end up being mutually reinforcing. And a public enforcer might pick up a pattern that's been litigated by a handful of plaintiffs. But I would just again come back to the point of resources: is that we can't rely on public enforcement just because there aren't always the resources there to make sure our rights are enforced, and that's where a private right of action is so important.
I appreciate that. I'm wondering, especially to immigrant communities and non-English speaking communities, how your organizations are able to access them versus kind of DCWP's resources. Do you feel like you have a deeper connection to those communities?
Well, MFJ provides services in all 5 boroughs, and we have language capacity, and we partner with community-based organizations. And so while I think there's always more work to be done and people, more people to reach, I think that we are embedded in the communities, and we are hearing from immigrants. We are hearing from non-English New Yorkers. We hear from small business owners who are immigrants. We hear from everyone, and then we also proactively go into the communities and try and find out what their issues are.
Right. And then just one last question, unless someone else answer that, but just Winston, on 177, what kind of resources and support would be helpful to managing the student debt issues that we're seeing going on in the city?
Well, I think I should say the city has done, and as I work across the country, although I'm a New Yorker, and the city is always leading the charge in terms of what local government can do. So continuing to add to that and update to that is great, and I really support that. I think making sure folks know that the city can be a trusted messenger, because there is, we heard from Isaac, there's so much misinformation, confusing information going out there. So providing accurate resources. But then to your last question to Carolyn, really getting out. I mean, the resources and materials themselves, I don't think are the hard part. I think the hard part is making sure they get to the people who need them the most. And doing outreach and making sure that outreach is accessible is important. I think the city also has an opportunity to through its other points of contact with community members, or through data and looking through its Office of Financial Empowerment and Outreach, really target certain communities for directed outreach and not just sort of have a blanket approach to how it gets student loan resources out there.
All right. Well, thank you very much. If there aren't any other questions for this panel, I don't see any. I appreciate all the panelists for being here. I really want to thank you for your dedication to the city. Thank you for coming on this snowy day to join us. And I hope you will stay on to listen to the rest of the panels. And I'm going to go to the second panel, which is Jessica Walker, Lindsay Vigoda, sorry if I messed that up, and Anthony Pena. And in that order, Jessica, you can go first.
Thank you. Hi, Chair Epstein and members of the committee. I'm Jessica Walker, President and CEO of the Manhattan Chamber of Commerce. I submitted long written comments, but here are the highlights. We support strong enforcement, but we need a system that distinguishes between malice and simple mistakes. Our recent data analysis reveals an enforcement system that is penalizing paperwork over fraud. 62% of resolved DCWP charges end in default judgments, meaning the business wasn't necessarily guilty, they simply did not respond. The overwhelming majority of charges are for administrative and signage infractions, such as missing a straws upon request sign. Small businesses are actively denied the opportunity to fix these minor mistakes because environmental laws like Skip the Stuff and the plastic straw ban lack permanent right to cure provisions. Even when violations are cure eligible, the system is broken. 55% of cure eligible charges have no recorded outcome in DCWP's reporting. So we really don't know if the cure policy is actually working as intended or not. We are also deeply concerned about DCWP's new protected time off benchmarks report, relying on national data to flag low sick leave usage risks, massive false alarms for small employers who may just have a healthy or seasonal workforce. We wish that there was a comment period before this was adopted. There's more in my testimony on that. Regarding today's legislation, Intro 410 risks becoming an unfunded operational and technology mandate. If the city requires small retailers to accept flex benefit cards, it must provide technology assistance and/or small business exemptions. We support Introduction 177 for student loan counseling, but it must be resourced independently so it doesn't drain DCWP's enforcement capacity. We urge you to build a smarter system. Mandate text message and email hearing notifications to fix the unacceptable 62% default rate. Create a mobile-first portal to easily upload photos to cure violations, and amend recent environmental mandates to include permanent cure periods. We must build an enforcement system and build enforcement systems that educate before they punish. Thank you.
Thank you very much. I think Anthony, oh no, Lindsay was next. Sorry, I apologize.
Thank you, Chair Epstein and members of the committee. My name is Lindsay Vigoda, and I'm the New York Director of Small Business Majority. As a representative of the more than 2.2 million small businesses in New York, thank you for the opportunity to talk to you about unfair and abusive practices for small businesses. New York small businesses are at a near breaking point between rising commercial rental prices, rising healthcare costs, a decline in traditional lending opportunities, and the stripping of many SBA or Small Business Administration lending programs. Running a small business in the city is extremely expensive and challenging. A survey we released in November highlights a portion of the position small business owners are currently in. Half of entrepreneurs reported a decrease in revenue in the last 3 months. In my work as a small business advocate, I've seen time and time again how in periods of economic uncertainty and turmoil like this, small business owners frequently turn to predatory lenders, often unknowingly, as a last resort to save the business they have worked so hard to build. With the decline in safe avenues of capital and the rise in AI and quick technology, this trend is only going to increase. While New York was once a leader in enacting policy to protect small businesses from bad loans, our neighboring states have now passed laws to stop unfair and abusive behaviors from those who target small businesses, while New York City and New York has not. We continue to fall behind on these common sense protections. Often lenders prey on vulnerable small business owners who have nowhere else to go. With the latest SBA ruling, which bars all non-US citizens from accessing SBA loan programs, predatory lenders will continue to fill the space, putting New York's immigrant small business owners at risk more now than ever before. It is important to note that nearly half of our city's entrepreneurs are immigrant-owned. And while access to capital is a pressing issue for New York's small business community, this is just the tip of the iceberg. Small businesses are increasingly facing more and more unfair practices. I've heard all sorts of stories, even in the last couple of weeks, from entrepreneurs in the city, from abusive collections practices to a business unknowingly without consent being signed up for an energy service company that raised their utility bill, to a corporation stripping a small business's catalog for their own use. In the city of endless opportunities, it is far too easy for small businesses to be taken advantage of and scammed. So I beg the question, what happens if we don't act now? With predatory and unfair practices taking over the small business landscape, it's time for the city to step up again and defend our most precious asset, our small business community. Thank you very much.
Thank you. Go ahead, Anthony.
Hello. Yeah, okay, good. Good afternoon, Chairman Epstein and members of this committee. My name is Anthony Pena. I'm a second-generation supermarket owner. I'm also the national president of the National Supermarket Association. And I'd just like to share you guys a quick story in that my father, when he started in the small bodega back in Yonkers in 1983, the bodega became a market, and the market then became a supermarket. Today, we're more than glad and proud to operate 8 stores over 4 states, including here in New York. And I'm proud to be in the business, and I'm here because independent grocers are the backbone of New York City's food supplies, and we are under serious threat. Over 80% of the groceries serving New York City are independent. We operate in every borough, in working class neighborhoods, immigrant communities, and areas where large chains dare not go and do not want to go. Our stores are not cookie cutters. One of our stores serves prominent Puerto Rican neighborhoods, and another serves prominent Colombian families and neighbors. In other stores, you will find different types of product from all over the world, from Portuguese to Italian products. So that's how different and dynamic our independent grocery stores are. We reflect the communities and where we serve. But we are being squeezed out, not because we failed consumers, but because of how the wholesale market is structured. But here's the reality. Dominant retailers like Stop and Shop, the Walmarts of the world, the Amazons of the world, the Costcos of the world, use their massive buying power to squeeze suppliers for the lowest possible prices and priority access to product that we do not have access to. So suppliers, they make up the difference by charging the independent groceries more. That means higher prices for New Yorkers. In some cases, mega retailers can sell identical products at retail for less than what I can buy them at wholesale. Let me repeat that. Their shelf prices are lower than my wholesale costs. Sometimes you don't see that in the retail costs because what happens is when they buy it at like significant savings, they match our prices, and then they make significantly much more margins than what we do. But that's not competition. That's structural economic discrimination. During the supply chain disruptions, I've had suppliers tell me there's no more product available. Yet I walk into these large super centers and see the shelves fully stocked with the exact same product I was told they didn't have any inventory for. Delivery trucks literally pass by my stores and to make sure that the dominant retailers are stocked first. When that happens, my costs rise, my inventory shrinks, and my consumers, your constituents, pay more. This is not an abstract economic theory. This is New York City cost of living issue. When independents are forced to pay inflated wholesale prices, these costs are passed directly onto the families that of where the families where the consumers are. And there is another side of the issue. When independent groceries close, they're not replaced by Walmart. They're replaced by nothing.
Time has expired.
Get Anthony, finish up. You go ahead.
Yeah, so pretty much when our independents close, nobody else goes in there to replace them. And if this consolidation continues unchecked, New Yorkers will have higher price choices, lower choices, higher prices, and controlled by enormous corporations. This is not the New York City we believe. The city has always been defined by its neighborhoods and independent businesses that serve them. We are asking for a fair chance to keep serving ours. Thank you for your time.
Thank you. I'll go to not. I'll just a couple of quick questions. So can I just ask around whether you think the CPL should be applied to small businesses? Should we be extending that statute to small businesses and get the benefits of those kind of protections that consumers are right now have under statute for fraud, misrepresentation that we're seeing happening across the city and the country? And I'm happy to any of the panelists to kind of, I don't know, Jessica, do you want to go first?
Sure. I mean, the devil's in the details, of course. Obviously, we want to protect good actors. There's no question about that. To the extent that we can, our concern is always, when we're passing laws that can be sweeping, that we are pulling in the good actors in some way and potentially harming them. That's really what, the big concern is. So yes, to the extent that we can protect, we are all for it, but it's about what those details look like and who's, what that actually means on the ground.
Maybe can I just follow up there because obviously small businesses are critical, though we've all heard from everyone on this panel how important our small business community is. And what we're seeing with the Amazons, the Targets, the Walmarts, not Walmart, most of New York, but these large stores, like how do we change the course and what do we actually have to do to, to ensure that fair competition, if not help small businesses not be, hurt by the larger businesses trying to do things that are, untoward. Like, it's, obviously deceptive practices happen, and how do we prevent that from happening if not through expanding the CPL?
I can respond. So here's what I would say. Part of this, I mean, it starts from the beginning. What is a deceptive practice? There's been a lot of talk, for example, about the food delivery apps and the where they're placing tipping and that sort of thing. I think it remains to be seen. What does that mean? Is that illegal? Is it unethical? Is it a business practice to drive revenue, which is what businesses are trying to do? So I think that's what I'm trying to say, is that none of this is easy. It really does mean looking at what are we talking about? What are the definitions that we're using? And how is that actually applied?
Okay. And then I just want your other point around kind of making sure businesses know these hearings are happening. You think creating, text messages, other tools to do follow-up that would be helpful for businesses? Do you think you'd have lower default rates if that happened?
I do. And part of it also is to, there's a whole education that needs to happen. Most small businesses, I can tell you in New York City, most small businesses have no idea about what is happening at the city council today or on any normal day. The laws, I don't think most small businesses are aware of these laws. And that is a problem. That's why the cure period is so important. But right, if they don't know that there is a cure period, if they don't know what that entails and how they can take advantage of it, then it doesn't matter that it exists. So I think it's all about education.
And you think that's through DCWP, through the chambers, through nonprofits, all the above?
All the above and more. Absolutely.
Thank you. Anthony, Lindsay, I don't know if you wanted to add anything.
Yeah, I actually do. And it also gives the businesses a chance, a fighting chance, because a lot of these small businesses, we don't have big councils, we don't have a lot of these budgets that these national chains are. Like, for example, now there's a big situation happening with Mondelez, which is Nabisco, your Oreos, and the company that delivers this to the retailers. Now, they sent us a letter just saying, you know what, we're not going to service independents anymore, but they're going to service the national chains. So these companies are getting away with murder. They're getting away with these things because they know that we don't have the resources to fight them. So now there's a legal something in place that we can say, listen, we can document these things. We can say, this is happening. We need help. Now they may think twice before making decisions like Mondelez just did for our independence, which is something which it doesn't even make economic sense. How can you have 1,080 grocery stores, 1,000 are independent, and only decide to go with 80 grocery stores to service the consumers on, that's going to end up higher cost for the product at retail level. So I just don't get some of these decisions. And then they know that they can get away. Robinson Packman hasn't been enforced in God long how knows. So maybe with this in place, we have a fighting chance, and that's kind of what we're looking for.
Great. Thank you. Go ahead, Lindsay.
Thanks, Chair. I would echo a lot of what my colleague said. Really, I think when we're talking about small businesses, we're talking about folks who, like Anthony said, don't have HR teams, don't have legal teams, don't have anything resembling that, especially in this city. As a small business owner, you're wearing about 1.5 million hats on any given day. And I think oftentimes when we say business, we have this umbrella term, and really the distinction is small business. And they need support, they need resources, and they need protections. And I do agree with what Jessica was saying that the right to cure is so necessary. A lot of folks, there are a lot of laws I can turn to that a lot of small businesses don't know that they are not in compliance. And if we extend any of these deceptive, unfair, abusive practices and include small businesses in those, making sure that small businesses have that right to cure, but also they often have the characteristics of consumers, and like we have all talked about on our panel, they tend to fall victim more than these bigger corporations to predatory practices. And that's where I think DCWP could be really helpful in enforcing and protecting small businesses in the city. And again, most of our city businesses are small and they don't have resources. So this is where the department can really step up. However, I will say there should be a private right for small businesses to act and be able to go after the folks and predatory lenders and predatory actors that they haven't been able to before, and get more resources that way as well.
So you think the private right instead of the extension of the CPL is a better path?
I will turn to my amazing friends and advocates who are on the legal team, or who are actually lawyers. And I know we have an amazing small business owner talking to that. But to get into the nuances, just protections, period, and ensuring that there is a way that we can change the system that we don't have to always go through city or state offices to get justice and seek justice.
It's helpful, thank you. Any last words? I don't see any other, my colleagues have questions, so I want to respect the panel's time. Then
Chair?
Go ahead.
I just wanted to weigh in on Councilman Riley's bill. I think that there was some confusion. People wanted to understand why there was some pushback on that, because it sounds like it's just an easy fix to make people take the flex cards. But I just wanted to clarify that these systems are actually regulated by the IRS, and it's not just you can't use the same system, the same point of sale system at checkout that you would for a credit card. It's not that easy. There is a whole other hardware and software that businesses would have to acquire in order to do that, and that's where the new costs come in, and that can be, between $1,200 and $3,000 to get the hardware up front, and then there are ongoing fees. You have to pay a monthly fee that can be about up to $3,000 annually. So I just wanted folks to understand why we have concerns about that.
It's a fiscal concern more than anything else.
Absolutely.
Yeah, it's really helpful to know, and if we can figure out ways to resolve the fiscal issue, structurally, you don't have a problem with having access to these cards. You don't want to make sure that these small businesses have to bear the cost.
Absolutely. So that's why we recommend that either there be some funding put aside so that businesses can fund that, or exempting the smallest of businesses.
And what level of exemption? When you say small, we define, so everyone defines small differently,
Yes.
In the
this
state,
instance,
99 employees are small, it's like.
You're absolutely right about that. In this instance, I would probably say 50 employees or below to exempt.
Right. Very helpful.
Thank you.
All right. I just, again, unless there's any last comments from this panel, I want to move on to panel 3. And if there are people who are here who would like to testify, you should notify the staff here at the council so we can add you. If you haven't signed up beforehand, it's your opportunity for the public. Obviously, this is a public hearing for public testimony. If you haven't signed up ahead of time, we'd love to have you testify. Next panel is Christine Hines, Chuck Bell, and Eric Kraus. And Christine, do you want to go first?
Yes, thank you.
Thank you.
Good afternoon, Chair Epstein and members of the Committee on Consumer and Worker Protection. My name is Christine Hines, and I am Senior Policy Director at the National Association of Consumer Advocates. I will submit written testimony, but here are the highlights. We appreciate this opportunity to appear before you to share our views on the oversight and enforcement of consumer protection law in New York City. As a global center for business and commerce, New York City should also serve as a model for protecting and empowering consumers, particularly the most vulnerable among us in the marketplace. In January 2025, as this Consumer Financial Protection Bureau prepared to transition to the current administration's control, the agency issued a recommendation to states to, quote, refresh their decades-old consumer laws. In light of developments on the federal level, New York's move to modernize its laws and boost safeguards for working families and small businesses is not only timely, but crucial. For decades, state laws that prohibit unfair and deceptive acts and practices have been key for enabling state governments, individual consumers to confront and stop harmful business practices that affect consumers' everyday lives. UDAP covers a wide variety of conduct, including insidious practices such as hidden fees and charges without consumer consent, unauthorized tracking and data collection, bait and switch tactics, delayed or withheld disclosures, and widespread financial misconduct such as predatory lending and abusive debt collection tactics. These days, consumers also face unfair and deceptive schemes connected to artificial intelligence and other evolving technology. The state's newly updated law, which added prosecution of unfair and abusive business practices for the Attorney General, signals a positive step for consumer protection. but it leaves an unmistakable enforcement gap that will obstruct its ability to achieve its goals. The new state law failed to give harmed consumers the power to act as private attorneys general and to pursue remedies on their own when they are harmed by abusive and unfair conduct. Private enforcement provisions in consumer and civil rights laws have long provided meaningful benefits to individuals and the marketplace in general. First, individuals bear the brunt of the costs when they're harmed by misconduct. When companies break the law, and individuals have a private right to seek remedies, that ensures that at least a portion of the cost of the misconduct will transfer back to the wrongdoer when they compensate the victims. Second, consumer-led enforcement is a prudent. Thank you. I would just like to say that I hope that New York City has an opportunity to implement proven techniques to facilitate broad and vigorous enforcement of its laws and to deter unlawful conduct. Thank you for listening.
Hi, good afternoon, Chairman Epstein and members of the committee. My name is Chuck Bell. I'm Programs Director for Consumer Reports based in Yonkers, New York. We're a national consumer protection organization. We are big fans of the Department of Consumer and Worker Protection. We think they do excellent work. We hope that they can be generously funded because they have many statutory responsibilities that are difficult to meet. We also strongly support a very strong consumer protection law and a strong consumer private right of action. I have submitted a written statement where I have outlined how we at Consumer Reports believe that New York City has really lagged behind the rest of the country in updating its consumer laws with respect to unfairness and abusive practices. And these are not just things that harm consumers on a one-off basis. They are things that create a sort of ecosystem where consumers are prone to lots of harm. And it's really a systemic problem. I put in the appendix a chart which compares the consumer protection laws of our neighboring states, Vermont, Connecticut, New Jersey, Pennsylvania, and Massachusetts. And then I took a look at some of the high-profile harms that consumers are experiencing today in 6 or 7 different categories, such as payment app scams, loan servicing abuses, credit reporting agency issues, auto finance abuses, hidden fees and junk fees, supermarket and consumer packaged goods harms such as shrinkflation, and dark pattern design on digital apps. So those are like 7 really broad categories. And each of those categories, our neighboring states have significantly stronger laws than New York State and New York City does. We as a polity have lagged behind in updating our law. And so the situation we face today is that we cannot protect consumers adequately in New York State or New York City with a law that hasn't been updated substantially since 1980. We can't do it. And so I was going to mention that we last summer worked with the County of Westchester, updated their consumer protection law to add unfairness and abusiveness. They did not create a private right of action, which we would have liked to see, and we hope that New York City will do. But they also upped their fines to $15,000, up to $15,000 per single violation. So I think we would urge the city to really strengthen the private right. We need the private attorneys and individual consumers to help enforce the law and create a strong deterrent against unfair behavior, and working together with the strong commissioner and staff we have at DCWP. That's the key to this. But we have many different areas where our laws are so weak that companies can routinely violate consumer rights with impunity without consequences. So thanks so much for having the hearing, and look forward to working with you.
Thank you.
Good afternoon, Chair and members of the committee. My name is Eric Kraus, Stakeholder Engagement Manager with the Education Debt Consumer Assistance Program, known as EDCAP, at the Community Service Society of New York. Thank you for the opportunity to testify. For over 180 years, CSS has advocated for low-income New Yorkers In higher education, we see the urgent need for stronger consumer protections daily, especially for student loan borrowers. Today, 1 in 4 federal borrowers is at risk of default. Borrowers still face servicer failures, steering into forbearance, misinformation, and missing records, while federal oversight has weakened, leaving little recourse when errors occur. A client's case shows the stakes. Rachel qualified for public service loan forgiveness after 10 years of dedicated service, but servicer mismanagement and the loss of over 4 years of payment records delayed the relief. Despite multiple complaints and records back to 2004, it took over 2 years to fix her file and discharge her loans. No one should lose relief because a servicer can't keep accurate records. The situation has worsened as court rulings push nearly 8 million borrowers out of the SAVE plan into less affordable options and higher delinquency risks. Instability fuels scams. Nadine was targeted by a document processing company that seized her FSA account, needlessly consolidated her loans, enrolled her in auto debit, and charged her nearly $800 up front, plus a monthly fee, an abusive scheme that was very hard to stop. This isn't administrative hiccup, it's a consumer protection crisis. Borrowers need stronger oversight, clear rules, and a way to enforce their rights. A private right of action is essential. Without it, borrowers remain powerless when servicers or third-party companies cause harm. We're also deeply concerned about the shift towards private loans under the One Big Beautiful Bill Act. The Century Foundation estimates 38% of consumers will struggle to qualify, with even higher barriers in low-income communities and communities of color. Families turn to private loans out of desperation. John's family did. Both his parents and grandfather all co-signed to keep him enrolled in college. Now 3 generations face financial insecurity. As federal and private options constrict, we expect more direct-to-school debt, balances owed to colleges that block re-enrollment and lack consumer protections. These debts go to collections or trigger lawsuits, undermining New York's investments through TAP, Excelsior, and public universities. New York must be prepared. We urge DCWP and city leadership to strengthen protections across education-related debt, improve private lending transparency, monitor emerging risks, partner with community and legal services, and critically enact a private right of action so harmed borrowers can seek relief. New Yorkers deserve a financing system that expands opportunity, not one that traps students and families in debt. Stronger consumer protections are essential to safeguarding our residents, workforce, and economy. Thank you.
Thank you all. And it sounds like there's some support here for the private right of action, which is really good to hear. Chuck, you mentioned other updates that you've seen across the other jurisdictions besides our private right of action. What would be your focus here for New York City?
Well, I think particularly with the worker protection responsibilities that the agency has, they do need more resources to be able to meet their statutory responsibilities. But beyond that, I think strengthening the law to clearly prescribe unfair and abusive practices would give the commissioner substantial authority to go after really large scale things. But I agree with what Erica said and Carolyn and others that there are many smaller scale incidents that crop up that where consumers do not have they can't wait for a regulator to intervene on their behalf. And because New York has the weakest law in the Northeast region, the businesses that cannot promote a deceptive debt settlement scam, for example, in Massachusetts, they can do it in New York. They can do it in New York, and they could do it in New York City. And so by strengthening the standards, we could have a really substantial deterrent effect. And like even without using the courts, companies they will realize that they can't practice things that are unfair. And that would include things like the digital apps with unfair design practices where they induce consumers to tip or they make it impossible to turn down a subscription. Those types of things are clearly unfair. There's a federal standard for it with the FTC and the CFPB, and there's a state standard. And so we're just lagging behind in updating the basic provisions that we should have in our laws.
Thank you. So I appreciate the updating the laws and giving more power to DCWP and giving more resources there. I don't have any more questions for this panel unless someone else, another committee member does. All right. Well, I want to thank this panel for being here and taking the time. I know on a snowy day there's a lot going on, so I do appreciate you all, and I look forward to follow-up conversations with you all as these things progress. All right, so I'll move on to the next panel. Adriana Lindenmayer, Joseph Rabella, and Benjamin Wolf. Ariana?
I'm not seeing Ariana on, so we'll go to Joseph.
Oh, thank you. Hi, Joseph.
Great. Can you hear me? Okay, wonderful. Good afternoon, Chair Epstein and members of the committee. My name is Joseph Rabella, and I'm the supervising attorney in charge of foreclosure prevention at the Bronx office of the Legal Aid Society. I offer this testimony along with some of the other people you've heard from today in support of a private right of action prohibiting unfair, deceptive, and abusive business acts and practices. I'm limiting my testimony to specifically focus on the areas of housing and homeownership, because we see these issues particularly keenly here. The major flaw in the GBL is that it only prohibits deceptive conduct, but many unsavory business practices do not rely on deception per se. Instead, they're taking advantage of the victim's lack of power and choice. And we see that especially in homeownership. So in a recent example, there was a mortgage servicer that illegally charged convenience fees for homeowners to pay their mortgage online instead of by mail. And these fees were unauthorized. The homeowner didn't agree to pay for them. But the servicer is not actually acting deceptively. They're fully disclosing this fee. It's just an illegal fee. What the servicer is relying on is not to fool the borrower, but that the homeowner is going to make the payment so they can stay current on their mortgage and stay in their home and avoid foreclosure. We see similar action in landlord-tenant situations where landlords will improperly bring actions in Supreme Court to avoid the legal safety net that's been set up by universal access to counsel. And although such action is legally defective, the tenant has no other recourse but to defend themselves in Supreme Court, which is the whole goal of the landlord in bringing the case there. They think the tenant's less likely to defend themselves. And just like a homeowner can't select their mortgage servicer, a tenant has no control over who owns their building. This lack of control is true in a lot of areas of importance in our lives. New Yorkers have no control over who services their student loans, which debt collectors purchase their debts, which credit bureaus and data brokers have access to their personal information. There are entire industries dedicated to extracting wealth from New Yorkers in a predatory manner, and they're able to do so without deception, which is why we need a broader catch-all of unfair and abusive practices as well. Thank you for the opportunity to testify today, and I'll happily wait for any questions you may have.
Thank you, Joseph. And I didn't realize that Ariana's sick today, and so we're going to add on this panel Ida Enries on this panel. So I don't know between Benjamin and Ida who wants to go, but you're both,
Chair Epstein, members of the committee. My name is Ben Wolf. I am a resident of the Upper East Side and counsel at the law firm of Whiteford, Taylor, and Preston, where part of my practice includes representing victims of consumer fraud here in New York and also New Jersey. I specifically mention our neighbor to the west, not by accident, but purposefully, because although it is merely 4 or 5 miles from where we physically are this minute, our state consumer protection laws could not be more distant. While the New York State Attorney General and the New York City Department of Consumer Worker Protection, the DCWP, play a critical role in protecting the city's residents, so do private lawyers like me. Every week and sometimes multiple times a day, New York City residents contact my office looking for legal representation concerning consumer fraud issues involving used car dealerships, solar panel companies, debt collectors, health clubs, home improvement contractors, some of the world's foremost financial institutions, many headquartered in this city, and other bad actors. The fact patterns are always the same: impermissible or extraneous fees, unsigned contracts, forged signatures, yo-yo scams, high pressure sales tactics, checking account fraud, you name it. Most times, I'm forced to reluctantly turn these potential clients away from suitable legal representation, where the playing field would be leveled against the bad actors hiring gigantic law firms, because New York's weak consumer protection laws make it almost impossible for these residents to assert their rights through the judicial system with the benefit of a private law firm. In short, New York's consumer protection laws obstruct our residents' ability to receive justice and monetary compensation. Conversely, when presented with the same set of facts in New Jersey, and at the risk of hyperbole, I could probably draft a complaint and file it with the court by tomorrow morning. As this committee considers the enforcement mechanisms of the DCWP, it should also appreciate how private lawyers like me can play an important role in helping protect New York City residents from consumer fraud. No matter what side of the political aisle you stand on, we all know somebody who has had issues with a student loan, a mortgage, credit card, motor vehicle, bank account, health club membership, or a home improvement project. And we can all agree they should be protected by comprehensive and strong consumer protection laws through proper legal representation. Thank you, Chair Epstein, and to the committee for your time, and I welcome the opportunity to answer any questions.
Thank you very much. Anita, go ahead.
Thank you, Chair Epstein and members of the committee. My name is Ida Henrys, and I'm the founder and managing principal of Henrys & Company. I'm also one of 85,000 small business owners who is proud to be a member of the Small Business Majority, a national nonprofit organization empowering America's diverse entrepreneurs to build a thriving and equitable economy. Today, I am pleased to submit testimony for the Committee on Consumer and Worker Protection, emphasizing the need to protect small businesses from unfair and abusive lending practices. I'm a proud entrepreneur and operate a financial advisory firm focused on small, high-growth companies. Most of my clients generate between $5 million and $50 million in revenue. I work essentially as a broker and an advisor who evaluates a business as it stands today, gathers information about the business's goals, and then develops a strategy to help that business raise the growth capital it needs. Although I work with highly successful small businesses, nearly every one of my clients has had some experience with predatory lenders. This happens because traditional banks have by and large exited the small business lending area, leading to a riskier capital landscape and leaving the market to be saturated with non-traditional lenders that often use unfair and abusive loan terms. In the last year, unpredictable tariff policies and rising commercial rent rates have made the cost of small business ownership in New York City unbearable for many. Meanwhile, we are seeing unprecedented federal cuts and restrictions to small business funding and new regulations from the U.S. Small Business Administration that bar non-U.S. citizens from applying for SBA loans, severing many legal tax-paying residents of New York City and New York State from the safest and most affordable avenues to capital for small business owners. It is important to note that nearly half of small business owners in this city are immigrants. So the effects of this ruling have vast implications for our economy and our community. The impact of this policy is not abstract. It is immediate and it is real. I'm currently working on an SBA loan application for a client who owns several restaurants here in New York City and employs over 100 people. My client was a lawful permanent resident and their spouse, a US-born Army veteran. Their loan was scheduled to close at the end of March. However, because of the recent restrictions barring green card holders from receiving federally backed small business loans and an arbitrary March 1 cutoff, their lender is now scrambling to salvage the transaction. If this deal falls through, the consequences will not be limited to one business owner. They will ripple outward to business partners, her more than 100 employees, their families, and the vendors and suppliers who depend on these restaurants. Not to mention the millions of foreign-born small business owners across New York.
Time has expired.
Hey, just finish up. Go ahead. You're good.
whose lifetime savings and generational wealth sits now in businesses that can no longer be reasonably financed. There's no threshold for ownership, even less than 1% bars you from a small business, a foreign ownership bars you from an affordable SBA loan. These issues compounded leave small business owners desperate for cash and more vulnerable than ever to abusive schemes. For example, a small medical practice in Harlem faced severe consequences when it was strapped for cash and accepted a predatory loan that eventually led to the lender seizing insurance reimbursement payments from a practice that serves cancer patients. This story is not unusual, and what my client had experienced wasn't illegal in New York. These often confusing lending arrangements skirt around traditional regulations to trap entrepreneurs into a debt cycle with little ability to break free. The lack of disclosures, enormous payments requirements, and unclear contracts can easily result in instances where a loan for less than $200,000 leads to daily payments of $1,000. New York has been a leading state when it comes to protecting small business from predatory loans, but the work is not complete. We must go further. We must not allow bad actors in the lending space to act without guardrails or in abusive but unfair ways. To continue to ensure our small business community can grow and thrive, we must provide it with meaningful protections from abusive practices by these lenders, vendors, and other predatory businesses. Thank you so much for allowing me to testify today.
Yeah, thank you all. And just on the CPL to extend to small businesses, is that in support of allowing the CPL to, like, we heard earlier, maybe businesses under a certain number of employees. Is that something that your group supports? Is that honorees?
I'm in the market. I'll let the lawyers opine on which they think is the best. Lindsay Pagoda, she speaks for small business majority, and the attorneys that I believe are supporting the small business majority. We support whatever path they think is best legally.
Yeah, I know we talked to Lindsay earlier, and maybe we can talk offline about that then.
Yeah. Thank you.
You're welcome. And Ben, it's basically the most important thing is the private right of action in your mind?
I do. I'm going to tell you right now, Chair Epstein, that we're coming to the end of the month, which means that most people's, vehicle leases are up, and I'm going to be sure that I'm going to be inundated with calls next week from people who've, gone last minute, probably this weekend, to purchase a car because they need it, Monday morning for work. And I can tell you that, you need a lawyer, or you get a lawyer in criminal court here in the city, and in sometimes in housing court. And I believe, and again, this isn't hyperbole, you should have a lawyer when you buy a used car. I'm going to get a lot of people calling me about that. Solar is a big issue, and there's just only so many tools that I have in my tool belt. When you work for a law firm, unfortunately, there's a bottom line. And if someone purchases a used car that, let's say, costs $16,000 and there's an issue, I just can't take that case on a contingency fee. That would be different than where I also practice in New Jersey, where under their Consumer Fraud Act, it's not as difficult. Then I could easily file a complaint based on a number of fact patterns. And I just think that we need to level the playing field. I believe that my friend Carolyn Coffey mentioned that. And just on the UDAP statute, Chair, I know Ariana isn't here, but she has an incredible map that just shows the kind of dichotomy between this state's UDAP statutes and all the other states in the union. And you'd be shocked, at the risk of sounding like an obnoxious New Yorker, you'd be shocked at some of the states that have better UDAP statutes than New York.
Yeah, thank you. I appreciate that. Appreciate your work, and thank you for all your testimony. Seeing no questions from my colleagues, I'll go to the next panel. Kevin Jones, Andrew Winokur, and Christopher Leon Johnson. And if there's anyone else here who does want to testify, she'll let the sergeant know, but we're on to this next panel. And Kevin, do you want to go first?
I'm not seeing Kevin here, so I'll go to Andrew next.
Okay. Go ahead, Andrew.
Okay, thank you, Chair Epstein and members of the City Council allow us to testify. This is in reference to the health benefits mandatory participation for small business owners accepting for business owners accepting credit card benefits. I submitted written testimony, but there are actually a couple of things which have been referenced in earlier testimonies that I'd like to respond to. I believe the president for the Manhattan City Council expressed her concern, Manhattan Chamber of Commerce, I apologize, expressed her concern about costs around participation in the program. And why that might be the case for a select number of instances and structures as it pertains to POS systems. There are a number of almost virtually free options available for participation by small and medium-sized businesses, where that, again, in POS integration costs may be obstacles. I probably should have started out by saying we're a technology platform that supports exclusively independent retailers in their ability to transact and accept OTC and grocery benefits across the United States. And so we have a virtually, cost-free solution that retailers can access that we think would be tremendously valuable should the legislation go through in New York City. And another point of reference, I think it was Jose Rojas from the NSA. I'm talking about his supermarkets, basically the challenges in big box and national chains versus independent community-based retailers. Acceptance of OTC grocery benefits is actually perhaps one of the very few places where there could be a level playing field as independent community-based retailers face challenges from big box and chain stores. Your ability to accept those benefits are on par. The members get the same amount of dollars, whether they use them at a big box chain or local independent community-based retailers. And we think this is sort of a situation by pursuing this legislation, sort of like helping independent retailers to help themselves. Many of them are unaware that these benefits exist and unaware that there are billions, that's with a B, of dollars that are eligible out in the community for people to come and shop in their stores. And so, the ability to have on par access to national big box chains is I think, unprecedented. And I will sort of give it a pause there. The rest of my testimony really just talked about opening access for food insecurity and lack of access and access to culturally relevant foods, which overall help produce a lot of health conditions. Thank you.
Thank you, Andrew, and thank you for sharing that. I would love to see kind of a lower cost option. So I hope you reach out to me and the council staff so we can see more about that.
Absolutely.
And Christopher Leon Johnson, you're next.
Yeah, hello, Mr. Chair Epstein. My name is Christopher Leon Johnson. I'm in the snow right now, but I want to make this clear that I support your bills, both the student loan bills and stuff like that. I support that. I got student loans, so I understand where everybody's coming from. That's more federal. Federal, they don't care because they the pockets with the Congress, so they're not going to do anything about it. But I want to make this clear that I think that I know with pre-budget talk that's in March, it's going to be up. I'm going to be talking about this more when it comes to the consumer protection and transportation. That the city council, I know that you had nothing to do with it, Mr. Epstein and Mr. Madani and Mr. Sam Levine had nothing to do with this, but it all falls on Senate Nurse, Justin Brannon, former Comptroller Brad Lander, then Councilmember Brad Lander, and Lydia Galapa, that they need to start allocating some money, like at least the certain amount of money to really help these guys and gals who's about to be laid off from Relay off when it comes to try to train them for OSHA trainings. This is my suggestion when it comes to this. Look, I'll make this clear that when it comes to this Relay, they leave in town. I think that this is foul. I mean, I think that the city council should come in and really step up to the plate and help these guys and gals out when it comes to making sure these guys and gals stay employed, have a job or able to get a job somewhere else, because Relay is where you went, where you got the FBA from DoorDash and Uber. And I think that this is up to you, Mr. Epstein. I know you're a small member, but you should be helping, leading the charge, and make sure that these guys and gals are protected after April 1st, 2026, when Relay leaves town. I make this clear that, look, that's my advice. That's my advice, Mr. Epstein. I know that you just came in the city council. You had nothing to do with this stuff. It doesn't fall on you, but you remember right now, and it's your duty to step up to the plate and make this clear, make this like a little initiation, starting in the city council to help these guys and gals out. Most of these guys here are migrants. Most of these guys here are immigrants, that need to work. And, if these guys get out of a job, what are they going to do? And I don't want to be looking at the paper that some of these guys committed heinous crimes. So this is my advice. When it comes to the customer, the city council need to be transparent and make sure that the customers are protected. When it comes to the new assuming more growth from DoorDash and Uber, when it comes to these apps growing after the law initiated, when it comes to intro 1332, that will protect these protect deliveristas that actually commit the more like heinous stuff from the customer. And there's a lot of concerns about domestic violence and stalking and harassment from these deliveristas after this bill becomes local law. But I'll make this clear. I know, like I said, pre-budget talk. This will be my target for pre-budget. That city council need to allocate some money with conjunction to Worker Justice Project and many other and the NYIC to make sure these guys who got laid on relay on April 1st, 2026 start getting prioritized trainings for driver placement, like OSHA trainings and stuff like that. So thank you so much and enjoy your day. Thank you.
Thank you. Thank you for this last panel. Is there anyone else who hasn't had the opportunity to testify who would like to? Either raise your hand, let the sergeant at arms know. If not, we'll conclude this hearing. I'll just give it one more second if anyone else wanted the opportunity to testify but didn't have it. I want to thank the council staff. I want to thank our sergeants here. I want to thank everyone who testified today. There's such an interesting conversation around overall consumer protection and what we need to do here in New York City to strengthen those the hands of both small businesses and consumers. And I really do look forward to next steps on all the legislation and all the ideas we had today. And with that, this hearing is adjourned.